Good afternoon, and thanks for joining us for a Tax Practitioners Board webinar. My name is Ashley Dowsard, and I'm joining you from Ngunnawal and Ngambri country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to lands, water, and community. I'd like to pay my respect to them and their cultures and elders past and present. To begin, I have a few housekeeping messages. First, to obtain a copy of today's slides, you can visit our Webinars Resources Hub at tpb.gov.au/webinar-hub. We'll also email you a copy of the slides. Today's webinar counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we will issue an attendance certificate to those attending for the duration of the webinar today. Today's presentation aims to help newly registered tax practitioners understand their obligations. We'll unpack the role of the TPB and tax practitioner ongoing obligations with the Code of Professional Conduct. We'll also share some real-life compliance case studies and answer some of the common questions we received during the webinar. We have Etty, Kristen and Georgia from our policy and legislation team to respond to your questions as we go. So please submit them using the Q&A. To find the Q&A, simply hover your mouse over the screen and a range of icons will appear on the bottom of your screen. We have a lot of people online today, so we may not get to all your questions. However, we will have FAQs available on our website following the webinar. You can also use the chat function to speak with other participants. We won't be monitoring the chat closely throughout the presentation though. To disable any of these functions, simply hover over the relevant icon and unselect Show Preview. Also, please remember to keep your comments courteous and professional. I'd now like to introduce our speaker, TPB Chair Peter Dacua. Thanks for joining us today, Peter. I'll now hand over to my colleague, Julie, to kick off the presentation. Over to you, Julie.
Thanks, Ashley, and good afternoon to everyone joining us today. As Ashley mentioned, the purpose of the webinar today is to discuss the role of the TPB and what we expect of tax practitioners in order to maintain your registered tax or BAS agent status. So, Peter, I'm just hoping that you can get us started today by setting the scene a little bit and talk about the profile of the registered tax practitioner community.
Thanks, Julie, and thanks, Ashley, for the introduction. Firstly, welcome to all of our newly registered tax and BAS agents and anyone else who's joining us today for a little bit of a refresher update. I really do appreciate the time that you spend in joining us for these sessions. It is really great to welcome all of our new tax and BAS agents into the profession. It's an exciting time at the beginning of your career. So I just thought it'd be interesting to talk a little bit about the makeup of the registered tax practitioner population. So as you can see from the slide, there's a total of nearly 64,000 registered tax practitioners, made up of nearly 47,000 registered tax agents and nearly 17,000 registered BAS agents. And that was as at just a little bit earlier this year. Now, of the 47,000 tax agents, nearly 68% of the agents are individuals. The other 32% are partnerships and companies. Of the BAS agents, approximately 78% are individuals and 22% are BAS agent partnerships and companies. Let's jump forward to the next slide, please. As you can see, just in terms of our own demographics as a profession, interestingly, overall, 47% of individual tax practitioners are members of a recognised professional association, which means that just over more than half of our population are not members of one of the main professional bodies and work mainly with the TPB in terms of their professional and ethical standards. 68% of registered tax agents are are male and 82% of registered BAS agents are female. In relation to the age profile, 58% of individual tax agents are over 50 years of age, and 65% of individual BAS agents are over 50. Let's talk a little bit about the work that you do in the tax system, and in particular in relation to lodgement of returns. So in the 22-23 financial year, 63% of individual income tax returns were lodged using the services of a tax practitioner, and 97% of company and partnership, trust and individual returns were lodged using the services of a registered tax practitioner. So that's approximately 2.4 million business income tax returns lodged and 10.1 million individual income tax returns lodged. I think this really illustrates the community's engagement with our profession of registered tax practitioners, and demonstrates the importance of having a well-qualified and ethical profession to service them. The Australian community generally has very high levels of trust in the tax profession, and in fact, our last biennial survey, 87% of the respondents said that they trusted their tax practitioner completely. So,
thank you for that, Peter. That's some really interesting information. I think that's really reassuring as well to hear those statistics about trust as well within the community. Would be really good if we can move on now just to have a look at what the purpose and the function of the TPB is as well.
Yeah, Julie, the Tax Practitioners Board is an independent statutory body that is responsible for the registration and regulation of the tax agent and BAS agent services in Australia. Our fundamental role is one of consumer protection, and so that to ensure that the community, to ensure the community that tax practitioners meet the appropriate standards of professional and ethical conduct. Before we sort of dive any further into this, I'd like to see if you know the role of the TPB well. So, Julie, over to you for a quick poll.
Yeah, no problem. Thank you for that, Peter. So the poll's just going to pop up on your screen in a moment. And what we'd like to know is, the question is, what is the role of the TPB? So there's a few different options for you to choose from there. So the first one is regulation of tax and BAS agents, ensuring compliance with the Tax Agent Services Act 2009 and the Tax Administration Act 1953. The other option we have is registration and regulation of tax and BAS agents, ensuring compliance with the Tax Agent Services Act 2009. And then the final option there in the poll is registration and regulation of tax and BAS agents, ensuring compliance with the Tax Agent Services Act 2009 and carrying out work under the Corporations Act 2001. So I'm just launched that poll, and as I said, that will pop up on your screen. So I'll give you a little bit of time to put through your responses. And then once we have those, we'll come back and share the results with you. Okay, we've got a few coming through. We've got about 30% so far. I'll keep it open just for a short time more, just to give everyone a chance. Okay, I might end that now. So thank you to everyone for participating. So Peter, it looks like we have about 25% of people saying that it is the regulation of tax and BAS agents ensuring compliance with the TASA and the Tax Administration Act. 35% of people have said it's regulation and ensuring compliance with the TASA alone. And then 39% of people have said it is regulation of tax and BAS agents ensuring regulation with the TASA and also ensuring compliance with the Corporations Act 2001. So I'll hand back to you to share the correct result with everyone.
Yeah, thanks, Julie. And whilst A is a little bit right, B is the complete answer, so B is the correct answer, and C, we don't have a specific role in relation to the Corporations Act, so that's just overcooking things a little bit. So let's move on to the next slide, and we'll talk about our purpose and our obligations to you as part of our registered population. The TPB itself was established about 15 years ago when the Tax Agent Services Act of 2009 was legislated through the Commonwealth Parliament. We bring together the previous 6 state-based tax agents brought into one Commonwealth regulator. As I've said, our principal purpose is to provide consumer protection for clients of practitioners and to register and regulate the tax and BAS agent population. So that clearly indicates that the correct answer is B. We are a separate independent body from the ATO, which is something that many people don't realise. But whilst we're separate from the ATO, we do work closely with the ATO to strengthen community confidence in the profession, and we do receive a lot of intelligence from the ATO that oftentimes ends up as the basis for some of the investigations and compliance work that we do. Our Tax Practitioner Service Charter outlines our commitment to practitioners, including your rights and responsibilities when dealing with us, and you can see that charter is available on our website. Our relationship with you and the wider community is based on mutual trust, and we nurture this relationship by trying to be open and transparent and accountable in our dealings with the community, and being professional, responsive and fair, especially in our dealings with the registered population. As I've said, our charter is available on our website, and we'll show you a link at the end of this particular session. So if we move on, and we'll just talk about how we're going about our own activities at the TPB. We've done a strategic plan for the TPB, and we've got a series of strategic pillars. The first one is pillar 1 is to ready our people, and this is really about making sure that we've got the right technology, the right people, they've got the right tools, and that we've got a good culture. This objective is all about making sure that we're properly prepared and we manage ourselves to achieve appropriate regulatory excellence. Our next pillar is about striving to foster opportunities to collaborate and partner. So in this one, we're working closely with the major professional associations. We run the Tax Practitioners Governance and Standards Forum. We have a consultative forum. We work closely with Treasury and the Assistant Treasurer's Office in terms of making sure that the system is working as best as it can, and that whatever reforms might be necessary are properly considered. Our third pillar is to make it easy for tax practitioners to deal with us, and we do this in a number of ways. You may have seen, through our registration process, we're trying to make it as simple as online forms that you're accustomed to with your professional association or other bodies. So we're working really hard to be easy to work with. We're publishing a lot of guidance and information materials on our website. We work really hard through consultation processes to try and make that as practical and as accessible as possible. And hopefully that helps you to streamline what you need to do in working with us. Our final pillar is strengthening our regulatory practice. And this really allows us to understand practitioner behaviour. It allows us to better target our compliance activities to the few practitioners who are generally high risk and doing the wrong thing, and not to spend too much time bothering the practitioners who are, abiding by the law, meeting their professional obligations and behaving well. So we're happy to send out our link to our 24-25 strategic plan that has more detailed information for those of you who are interested. Let's jump forward into the next slide. And I just want to talk quickly about the availability of the registered tax practitioner symbol. So we make this symbol available to you for your use. It does a couple of things. One, it can help you promote your own practice if you use it combined with your own personal or business tax agent or BAS agent registration number. You can use it on your website, on your emails, on your letterhead. It clearly demonstrates that you are a registered practitioner, whereas other potential players in the industry might not have bothered to register and are running about being inappropriately qualified and unskilled in comparison to you. So this is an important part of demonstrating that you are part of the registered population. And it helps to reassure taxpayers and businesses that you have the right qualifications, experience, and skills to look after their affairs. Okay, that gets you set up. So let's have a little bit of a look at your ongoing registration requirements. So for a lot of you who are new registrants with the TPB, you're probably quite familiar with this, having gone through a recent registration process. But for those of you taking a bit of a refresher, we'll go through it as well. So in order to be registered, one of the first requirements is that you must have in place and maintain a professional indemnity insurance cover that meets our requirements, and you must disclose to us through our website and your registration forms the details of this cover. PI insurance policies are critical consumer protection, and they are how you look after your clients and look after yourselves in the event that there is any dispute or any problem. So it's a basic consumer protection. I think it's really important to understand that some of the services you provided are clearly covered, and generally, hopefully, it covers any technical or negligence problems. It could potentially cover third-party cyber liability or hacker liability, cyber extortion, data breach notifications, and public relations costs. One of the things I strongly recommend to you is don't assume that your PI policy covers you for everything. Check what it does cover you for, because not all of them are as strong, especially in the cyber section, as you would hope they are. Let's keep moving through the registration requirements. Hang on. I've got to get to the right page. So in the ongoing requirements, obviously you're obligated to meet the qualification and relevant experience requirements before you're registered. And for individuals, once you are registered, you have obligations to meet the continuing professional education requirements. And we'll discuss this in a little more detail later. You must notify us within 30 days of any changes in your circumstances. If you cease to meet any of the tax practitioner registration requirements, you must notify us if your circumstances change, in particular in relation to the changes in the composition of a partnership or a company that is a registered agent. You need to notify us as soon as possible, generally within 30 days, in writing of those changes. Generally, that can be done by using the portal section of our website. You must also notify us in writing if there's a change in your business address, email address, or any other circumstances relating to your registration. Another of your ongoing registration requirements is that you must continue to be a fit and proper person for the purposes of the Taxation Services Act. Before we go into what a fit and proper person assessment criteria is, we should know who these requirements apply to. So, Julie, can you do a quick poll for us, please?
I sure can. Thanks, Peter. So again, this is another multiple choice question. And the question we're asking this time is, who must satisfy the fit and proper requirement in the TASA, which is the Tax Agent Services Act 2009? So you've got 4 different options for you to choose from. First of all, we have individual tax practitioners. Then we have directors of a company tax practitioner. We have directors of a company partner, of a partnership tax practitioner, and then we have individual partners of a partnership tax practitioner. So those 4 options there for you to choose from. So I've just launched that survey for you. Hopefully that's popped up on your screen. I'll give you some time to respond to that. Oh, it looks like people are saying there's a bit of a problem for that that poll there. Let me try that again.
I can't see the poll, Julie, so
Yeah, it's strange.
at least I can't get it wrong.
This is very true. It doesn't seem to want to work for us today. It's a bit of a...
Well, let's just jump forward.
Let's move on. If you want to just give us what the answer is, Peter, that would be great. Thank you.
Yeah. Well, I think this is one of the classic all of the above answers, isn't it? So everybody who is involved in as a registered practitioner themselves, as a director of a company which is a registered practitioner, partner in a partnership that's a registered practitioner, or individual partners of a partnership that's a registered practitioner, you all must satisfy the fit and proper person test. So what this really does is make sure that only people who are fit and proper can be involved in the provision of tax agent services under our auspices. And I think that's really important, that for the public to be able to trust everybody who is in the profession. So just moving on, as well as being a fit and proper person, and perhaps we might just talk about what the requirements are. When we're looking at making a decision about fitness and propriety, we look to see if the person is of good fame, integrity, and character. We look to see if they've been convicted of any serious tax offences or any other offences involving fraud or dishonesty. We look to make sure that they're not an undischarged bankrupt, whether they've been sentenced to a term of imprisonment, or whether they are currently meeting their own personal tax obligations. And we'll talk a little bit more about that later. So registered tax practitioners can also be subject to civil penalty provisions for certain types of conduct. And these include things like making false or misleading statements to the Commissioner of Taxation, potentially signing declarations and statements that have been prepared by someone else who is unregistered or not under the supervision of a registered tax practitioner. From the time you register with us, you are required to comply with all of the obligations under the Code of Professional Conduct, or the Code for short. So we'll talk through those in a little bit more detail in a minute. But the Code is really the place where you can pretty easily and simply read through what your professional and ethical responsibilities are in relation to the TPB, your clients, and with particular reference to your own conduct. So if we jump on to the next slide, please, and one more, the Code of Professional Conduct is outlined in the Tax Agent Services Act and in the 2024 Ministerial Determination that was issued by the Assistant Treasurer last year. But there are 17 core principles in the code, and these core principles are grouped under 5 key categories. The key categories are about honesty and integrity, independence in your professional activities, confidentiality in relation to your client's personal, private, and business information, and also in relation to government information if you're working for government. Competence is a core pillar, and there's a group of other responsibilities which I'll go through in the course of this afternoon's session. So let's jump forward and talk a little bit about the first principle of honesty and integrity. Under this principle, you're required in all of your business dealings, especially with your clients, to make sure that you conduct yourself with the highest standards of honesty and integrity. You are required to comply with the taxation laws in the conduct of your own personal affairs. And additionally, if you receive money or other property from or on behalf of a client, and you hold that money or property on trust, you must account properly to your client for that money. Under the independence principle, you must act lawfully and in the best interests of your client, and have in place adequate arrangements for the management of any conflicts of interest or conflicts of duty that could arise. The confidentiality principle outlines that you must not disclose any information relating to a client's affairs to a third party, either unless you've got the client's permission to make that disclosure, or if there is a legal duty for you to make that disclosure. Under the competence principle, you must provide a competent service, and you must take reasonable care in ascertaining the client's state of affairs, and you must ensure that the taxation laws are applied correctly. Moving on to slide 20, please. Under the code, you also have a range of other professional responsibilities. So firstly, you must not knowingly obstruct the proper administration of the tax laws. So that's about honest dealings with the tax system on behalf of yourself and your clients. You must advise your client of their rights and obligations under the tax laws that are related to the tax practitioner services that you provide. You are required to maintain PI insurance that meets our requirements. You are required to respond to any directions from the board in a timely, responsible and reasonable manner. You must not employ or use the services of an entity to provide tax agent services on your behalf if you know or ought reasonably to know that that entity is a disqualified entity and the board has not given you approval to employ or use the services of that disqualified entity. You must not provide tax agent services in connection with an arrangement with an entity that you know or ought reasonably to know is a disqualified entity. You must also comply with the specific requirements determined under Section 3012, which is the ministerial determination that I've referred to earlier. There are 8 additional code items that have recently been introduced under Code Item 17. And importantly, these obligations commence on the 1st of July 2025 for tax practitioners with 100 or less employees. If you have more than 100 employees, these obligations started from 1 January this year. In the interest of time, I'm not going to go through these specifically, but I would encourage you to view the recording of the code determination webinar that I did this morning, and we're happy to send you a link of that webinar at the conclusion of this webinar today. But I will say that the 8 additional obligations are very consistent both with the core principles of the code and with the requirements of all the international accounting and ethics standards through the ethical standards bodies. Okay, let's jump forward to the next slide, please. This is about your obligations in relation to responding to board requests. So as I touched on earlier, you may receive a request from the or directions from the TPB. You have a legal obligation to respond to these requests or instructions in a timely manner and a responsible and appropriate manner. The board may contact you and request information, including information relating to your PI insurance or your CPE compliance or your general compliance with the code itself. Examples of failure to respond to a board request in a timely, reasonable manner may include failing to provide a written response to board correspondence within the time specified. So when we write to you, we will generally specify when you need to reply by. It will most normally be 28 days. Making arrangements with the board to provide information and then subsequently failing to meet the arrangement that you've made or provide the information in accordance with that arrangement. Or providing responses to the board and or to requests or directions that are either false or misleading. So you must deal honestly and openly and transparently with the board, and you must do it in a timely fashion. And if you're not doing that, you will have breached the code and make yourself potentially subject of disciplinary action. So let's jump forward to the next slide, and I'd like to talk about complying with the taxation laws. So a specific obligation under the code is that you are obligated to comply with the taxation laws in relation to the conduct of your own personal affairs. This includes on-time lodgement of your personal income tax returns, activity statements, payment of super guarantee contributions, payment of PAYG and withholding and instalment payments. At the TPB, we take a really dim view of practitioners who don't meet their obligations, in particular for SGC contributions for their staff and PAYG contributions for their staff. Now, just to flesh out what does it mean, your personal tax affairs, that means that it relates to yourself, your associated companies, trusts and entities, and making sure that all of the things that you are potentially in control of are appropriately up to date. So you need to make sure that all of those obligations for yourself and your associated companies and trusts are up to date. In the event that you are having trouble meeting your tax obligations, if you can enter into and maintain and keep up a payment arrangement with the ATO, we will accept that that is complying with your own personal obligations. But if you fail to meet the payment arrangements that you agree with the ATO, you'll be back in breach. So there is significantly more information on this topic available to you through an information sheet, and we'll send a link to that out at the end of this webinar. Let's move forward now, and we'll talk about what reasonable care means from our perspective. So, two items of the code relate to taking reasonable care to ascertain your client's state of affairs and to apply the taxation laws correctly. Here are some steps that we think could assist you to meet your obligations in relation to reasonable care under the code. Firstly, we need you to make sure that in everything you do, you exercise appropriate professional judgment and take into account the relevant factors. One of the things we really think is important is for you to use signed engagement letters with clients, so that the terms of your engagement with those clients are clear and understood by both parties. There's a common understanding of what work you are doing for them and what work you're not doing for them, what's out of scope. This, we think, is a great assistance to you both in avoiding disputes with your clients, but also in protecting yourself and working with your professional indemnity insurers in the event that a dispute might arise. Okay. Let's jump forward. Hang on. Yeah, let's jump forward into slide 23, and we'll talk about a little bit more. I'm a little bit out of order, sorry. Now, also specific things that we think you should be doing to take reasonable care. This is about the services that you provide personally and also those that are provided by your staff on your behalf. So we need to make sure that you've got adequate systems of supervision and control. So all registered practitioners are obliged to ensure that the services they provide are provided competently and that you have policies, procedures and systems to provide that supervision and control to any staff members who are providing services on your behalf. You should also take appropriate relevant steps to ensure that you have all the relevant information, that you've properly considered it. So part of that is about making appropriate further inquiries, asking your clients the relevant questions about their own personal circumstances and tax affairs and financial affairs. If you're not yet certain, seek further information, ask more questions. And also, we think it's really important to understand the limits of your own skills and knowledge. So seek guidance from other professionals if the matter is outside your area of expertise. We also recognise, we're going to jump forward and talk about CPE hours now. Thank you. So once you're a registered agent, you have an obligation to meet every 3 years in relation to CPE. For tax agents, you must complete 120 hours over the 3-year period, and in each of those years, you must complete at least a minimum of 20 hours. For BAS agents, over the full 3-year period, it's 90 hours, but still a minimum of 20 hours in every year. CPE must be relevant to the tax agent services that you provide. There's lots and lots of different sources, including our own TPB webinars, seminars and workshops, using structured education conferences and programs that are available through the professional bodies, tertiary courses and other education courses that are made available by universities and technical colleges. There's research, writing and preparation by a registered tax agent or BAS agent of technical publications or structured training. In-house training is, if it's properly thought through and structured. Computer and internet assisted courses can qualify. As I said, attendance at structured in-house training is a great way to meet CPE requirements. and also tax relevant CPE provided by recognised professional associations. Our policy also specifically recognises that cybersecurity training for a tax practitioner is eligible training in terms of your CPE. We also recognise that health and wellbeing activities and training to assist you to manage your own mental health and potentially the psychological safety of your own staff members is eligible for up to 10% of those CPE activities. So, Julie, can I hand back to you, and we'll run a poll on the CPE rules.
You sure can. Thank you for that, Peter. So we're just going to test everyone's knowledge now on CPE. So again, we've got another multiple choice, but this one's based on a scenario. So in this scenario, we have Stephen, and Stephen is a registered BAS agent. Stephen attends a training session by Master Software. He uses the Deluxe Master Software package developed by Master Software to assist him in providing BAS services to his clients. So Stephen recognises that the training session he's attended is indirectly relevant to the BAS services that he provides. He also decides to attend an online seminar from Beyond Blue about managing his mental health. So the question that we're asking you here is, which courses do you think Stephen can claim as CPE under the TPB's policy? So we've got three choices for you here. So he can claim both the training sessions by Master Software and the online seminar from Beyond Blue. Secondly, only the Beyond Blue online seminar is eligible to claim under the TPB's policy. And finally, only the Master Software training session is eligible. So I've just launched that poll. Hopefully that one's worked this time. Looks like it has, which is great. Yep. And again, I'll just give you a few little seconds there to put through your responses, and then we'll share those with everyone in a moment. Now, I'll just mention quite a few people in the chat today have had concerns about not being able to enter the webinar that we did this morning. It was at capacity. We did have a really unprecedented amount of people register for that session. So I do apologise if you couldn't make it into the session. We did have a live stream on YouTube, so hopefully some people were able to watch it there, but we also did record it. So that recording will be available on our YouTube channel, and that should be available either this afternoon or tomorrow morning. And if you do subscribe to the channel, you will get a notification when that's available for you to view. So highly recommend that you do that. So when you subscribe, you'll receive notifications on all of our videos as well. So just, I'll finish that poll now, ending that. And I'm going to share the results so everyone can see them. So Peter, what we've got there is 73% of people believe that Stephen can claim both of those courses. 7% believe that it's only the Beyond Blue that can be claimed, and 20% have said only the Master Software training session. So I'll hand back to you, Peter, and you can tell everyone what the correct response is. Thanks, everyone.
Yeah, thank you, Julie. And as Julie mentioned, this is our second session today, so it's a long day of webinars. But in relation to this poll, the correct answer from our perspective is number one. So we're happy for Stephen to record and claim both of these courses for CPE purposes. The Deluxe Master Software package is a package that Stephen is using to provide taxation services to his clients, in particular BAS lodgement services. So it's really important that a competent practitioner is proficient in using the software package. So we're happy that that's directly connected to his BAS agent services. We also think that the Beyond Blue course is a great contribution to helping Stephen manage his own mental health and potentially help him with any issues that arise with his clients. So we're happy for that to be treated as CPE, and as I said, up to that maximum of 10% of your annual and triennial obligations. So let's on that note, let's move forward and we'll have a little bit of a chat about the penalties and sanctions that can be applied to tax and BAS agents who aren't doing the right thing and who don't meet their obligations under the code. So the the sanctions that are available to us at the TPB include, from a written caution, which is simply a note to you as a practitioner saying, well, look, we've noticed that you're doing these things. We're not happy about it. Here's a caution, don't stop doing it and do better in the future. An order is after a proper and procedurally fair investigation. If we find that you've breached the code, we may make an order that could require you to complete a certain course of education. It might be a course in, say, work-related deductions, or it might be a course in the TASA itself. So we make those orders where we see that people have been deficient in their own education, knowledge and skills. And we very typically make an order to get up to date with your CPE requirements if you've fallen behind with those. And we very regularly make an order for a practitioner to get their own personal tax affairs in order within a short period of time if they haven't done that. We can make orders in relation to limiting the scope of services that you're allowed to do. So it might be an order that you only provide individual tax returns, or that you're allowed only to do superannuation fund returns, for instance. So we can make an order like that. In the more egregious bad behaviour cases, we can suspend or terminate. There are a limited range of circumstances in which a suspension is appropriate, and that might be in fairly bad behaviour or fairly poor compliance with tax affairs. We might suspend your registration until you've got your personal affairs back in order. For the most serious bad behaviour, we have the capacity to terminate your registration, which withdraws your legal right to practice as a tax agent. When we make a termination, we also will make a ruling on the period in which you are not eligible to reapply for registration, and the maximum period we can impose at the moment is up to 5 years. I will emphasise that if you are terminated at the end of the no application period, when you come back to apply for your registration, you then have to demonstrate to the TPB that you meet all of the registration requirements and that at that time you are a fit and proper person to be admitted. As I've tried to indicate, the severity of the sanction will depend on the nature and extent of your breaches of the Code of Professional Conduct. So the more serious the behaviour is, the more serious the penalty will be. And oftentimes we find that people are repeat offenders and don't learn their lesson. That automatically sort of kicks you up the list in terms of how badly your behaviour is perceived. On any decision that the TPB makes in relation to either breaches of the code or imposition of penalties, practitioners have a right of review with the Administrative Review Tribunal. So any of our decisions are appellable to that tribunal. In certain circumstances, the board can also make application to the Federal Court, who can impose a pecuniary penalty for each breach. Individuals could receive a maximum penalty of up to $82,500 for each individual breach of the code, and bodies corporate could receive a penalty of up to $412,500 for each individual breach. So let's perhaps use a few case studies to flesh out and demonstrate these rules. The case studies serve as a reminder to all tax practitioners to be vigilant when it comes to their obligations under the code. And in particular, sufficient supervision is a necessary requirement for all practitioners' registration and enables us to maintain trust within the community and integrity of the profession. So in this example, found a tax agent breached Code 7 by failing to supervise an employee under their control. The Board Conduct Committee, so the case was presented to the Board Conduct Committee, and the BCC found that the agent failed to adequately supervise the activities of their client, in particular, activities of their staff member, in particular by allowing their personal MyGov ID credentials to be used to access confidential client information, and the lack of supervision and appropriate internal control processes resulted in that employee misappropriating $319,000 of client refunds. The tax agent themselves reported the incident to the ATO, and they also reported themselves to the TPB and to the police. They also ensured that all of the refunds that had been stolen were repaid to the clients. So, on the consideration of all of these issues, the TPB determined that there had been a clear breach of Code Item 17 for failing to supervise an employee, but under the circumstances where they had self-disclosed and taken appropriate action to mitigate their clients' losses and worked constructively with the TPB, we notified them of their breach of the code and issued them with a written caution. This case clearly serves as a reminder that you need to take great care in supervising the staff under your control. Okay, let's jump forward into case study 2. And this is a case study about a BAS agent. We terminated the BAS agent's registration and imposed a 5-year ban after they lodged BAS returns on behalf of a client without the knowledge or authorization of the client. By doing this, the agent was able to misappropriate the client's refunds. They then made false and misleading statements when they lodged the BAS because it contained false and misleading or false information, incorrect information, and this led the ATO to issue refunds that the client was not entitled to. The agent also then went on to provide false information and documentation when they attempted to prevent us from investigating and performing our duties. So the outcome of this, as I said, was a 5-year ban, and the BAS agent is no longer able to practice. And one of the serious issues here was that this was not the first time the agent had lodged false returns, and it was clear that no matter what sanction we imposed on them that might have been lesser than a termination, that they weren't listening. So that took us to the point where we needed to impose the full 5-year ban on reapplying. Let's go to case study 3. And the final case study is one in which we can demonstrate a couple of things. Firstly, at the TPB, we do take it very seriously and put significant effort into trying to curtail unregistered tax practitioners, because one of the dangers that they put out for their clients by not being properly qualified and regulated, but 2, also to make sure that there is a level playing field for those of you who are properly qualified and registered, and that you're not competing against unregistered practitioners. So in the case of Ms. Jess de Abelos, she's also known as Jessa Van Stroh and Jessa Layola, she had been lodging tax returns without being a registered agent. She'd been discovered through work between the TPB and the board. We had gone to the federal court, and the federal court had issued an injunction to tell Ms. Dabelos not to lodge any further tax returns and not to engage in any further misconduct. And the federal court imposed a $230,000 penalty. And again, it was a permanent injunction. Despite the penalty, and despite the fact that there was a permanent injunction from the federal court, she continued to lodge tax returns, and we were able to demonstrate another 365 occasions where she had lodged returns. The federal court found that each individual occasion was an occasion of contempt of court. The court, on that finding, imposed an additional penalty of 12 months imprisonment. So I think this demonstrates the importance which our system places on being an appropriately registered, professional and ethical provider of tax services, and the danger to the community that is imposed by having unregistered practitioners. So we continue to work hard to address unregistered preparers and to protect the community and support the integrity of the profession with that focus. So on that note, I'd like to finish up and hand back to Julie and see if there are any questions from the audience today.
Thank you for that, Peter. We certainly do have some questions for you, so you're not off the hook just yet. So our first question comes from Lindsay, and Lindsay wants to find out a little bit more information on the personal tax obligations that you spoke about earlier in the webinar. So Lindsay's wondering if you're actually on a payment plan with the ATO for personal tax obligations, you have a liability, do you have to report that to the TPB?
Yes, if you've made a payment, if you're behind on your payments and you make a payment plan with the ATO, that is a matter that's relevant to your registration. So you should report it to the TPB, and then we're able to make sure that we work with you to keep you on track. But once you've made a payment plan, you must comply with it. And if you're not complying with it, you should also notify us of that, because if you're unable to do that, we'll have to potentially take some action with you.
Thanks for that information, Peter. The next question I've got here is just in relation to the case study you just went through on that unregistered preparer, Miss DeBolis, I think it is. The question is, were they actually charging fees for lodging the tax returns?
Yes, they were. So the TASA only applies to the provision of taxation services for a fee or reward. So Jess Dabalos had over many years recidivistly lodged tax return on behalf of her clients, but was not a registered tax or BAS agent, and she charged a fee. Generally, when the federal court imposes a fine, they will have regard to the amount of money that the person has charged over their offences to determine an appropriate fine.
Thank you for clarifying that. That's great. The next question I've got here is from Douglas, and Douglas is curious about CPE hours. Just wondering if they watch the YouTube videos, can they still claim their CPE?
Yeah, our YouTube videos are clearly eligible for CPE. So, we do ask that make sure you watch them all the way through. Make sure that you keep a contemporaneous CPE log, and that will help you to meet your obligations.
Great, thank you for that. So the next question I've got here is around registration renewal. So if I don't renew my registration by the due date, will I lose my registration?
Look, technically, yes. You are obliged to renew your registration on time every year. When there is the occasional honest mistake or lapse, our registration team will work with you to get you back on board as quickly as humanly possible. But we genuinely encourage people to get their renewal done on time every year. It's a pretty simple process these days.
That's great. Thanks, Peter. And people can just check that on my profile
Correct.
as to when their registration's due as well.
Yeah, can I just add one thing? A number of times I've had practitioners who've rung me directly instead of ringing our registration team, and they'll always be the same old complaint. Oh, my assistant, my PA, or whoever who does the administration of the firm forgot and didn't do it. Well, the simple thing I've got to say to you is your registration is your registration, and you're the one that's responsible for it. I know that everybody's got plenty to do, but it's your license to practice, and you're responsible for it. So perhaps put it in your own diary and do it yourself.
Yep. Good answer. Thank you, Peter. I've got a couple of questions here just asking about attendance certificates for the webinar. We will be issuing those tomorrow, so they shouldn't be far away for everyone. The next question I've got is around the termination of someone's registration. So if the TPB terminates someone's registration because they haven't complied, can they then go and reapply for another registration?
Yeah, so in the first instance, when we terminate your registration, we will advise of the reapplication period. So once it's very rare that we'll terminate and not advise at least a 1 year no reapplication period. But at the end of that period, you're eligible to reapply. But as I've said, anybody who's reapplying has to be able to demonstrate that they meet all of the registration requirements and that they are a fit and proper person at the time they're making that application.
Great, thank you. The next question I've got is from an anonymous attendee today, and they're just asking, as a tax agent, do we have to complete an ID check on all new clients, and how do they record those verification processes?
So the proof of identity obligations apply to all new clients, and you need to have done enough to make sure that you have proven the identity of your ongoing clients. Now, as everybody I think will understand, we're not asking you to keep photocopies of people's driver's licenses or their passports or any of their other personal identifying documents. What we want to be able to see is that you've demonstrated through your normal practices in your files that you have a procedure for doing this and that you have ticked off those procedures. So I would have on my files, if I was in your shoes, I'd have a checklist that goes through the items that you need to cite to prove identity, be it a driver's license or a passport or a Medicare card, and you'd have a tick box and a date next to them. And once you've, tick the box that you've cited the passport, write in the date that you've cited the passport and have that available on your file. And that's the sort of genuine professional record keeping that we expect to see. But I reiterate, you don't have to have a copy of the passport. You don't have to have a photocopy of the driver's license. You just need to have demonstrated that your processes require these things to be done, and you tick them off and date them.
Great, thank you for that. I've got another anonymous question here, Peter, but this one's relating to code item 6, which is confidentiality. So the question's asking, could you please advise whether sharing an open plan office with another firm would breach code item 6? If a client information is secured stalely in a locked area and the tax agent appears independent, for example, displaying their company logo at the front of the building, can you see any issues there?
Yeah, thanks, Julie. I'm really comfortable that it's possible to work in those circumstances and do it confidentially. As you've mentioned, you need to have appropriate secure lockup for individual records so that those things are not easily accessible by your co-tenants. I think you need to be really mindful of what happens when you go out to an appointment or you go out to lunch, not leaving things lying on your desk. You need to make arrangements to pack those confidential records away in a locked and inaccessible fashion. And I think you need to make sure that whatever IT systems that you're using, make sure there's no shared IT systems. And you may well be in a set of circumstances where you might be sharing some administrative support across those various tenants. So just make sure that if you've got people that are engaged in more than one business, might be an EA or a receptionist or somebody that's doing some of the work, just make sure that they're fully schooled up and supervised on those matters. But I'm really, really can be comfortable that it's possible to do that appropriately.
Thanks for that advice, Peter. That's helpful. I know that we're almost at time, but I have just a few questions here. People have been asking about registration, whether it's 1 year or 3 years. The registration process did change to an annual process, but just wondering, Peter, if you could just give a bit of further advice on that, please.
Yeah, sure. So our registration process is now a 1 year process. So for all new registrants, you will do a renewal every year, and it's a simple renewal online form, pay with your credit card. For those of you that have got an existing 3 year registration, you will start on the 1 year renewal process at the end of your current 3 year renewal. So if you're 2 years in, you're only a year away. If you renewed just before it started, you're still a couple of years away. But it's a rolling thing. So if you've got a 3 year registration, you'll go to yearly at the end of that current 3 year term.
Great. Thanks, Peter. Hopefully that answers those questions. So I just wanted to quickly give a little bit more information on how to stay in touch with the TPB. So if you'd like more information, I highly encourage you to have a look at our website, tpb.gov.au. You can also follow us on LinkedIn and Facebook. You'll find the most up-to-date information there. You can also subscribe to our newsletter, which we issue each month, TPB e-news. So just again, go to our website, tpb.gov.au and /newsroom, and you can subscribe there. You can also subscribe to the YouTube channel, which I mentioned earlier. If you do view anything on the YouTube channel, as Peter said, you can still claim your CPE for viewing those recordings. So just wanted to say a big thank you to Peter for all his helpful information today. Thank you to Eddie and to Kristen and to Georgia for helping out with the questions as well. So that was great getting all of those responded to. If you didn't get your question answered today, we will put together some FAQs on our website. So we'll address the common questions there. So once again, you can claim CPE for attending, and we hope that you've found this webinar beneficial to you today. So just one last thing, before we finish up, I'll be launching an exit survey, and it would be wonderful if you could just take the time to complete that. It's really quick. It's only a moment of your time, but it does help us improve the webinars. And also, if there's any topics you'd like to hear about from us, let us know in that survey, and we do go through those and have a look at topics to formulate our next calendar of events as well. So that survey just opens up in your browser when you finish the webinar today. So once again, thanks for joining us, and we do hope that we can connect with you all again soon. Thank you, everyone, and thank you, Peter.
Thanks, Shirley. Thanks, everyone.